we're going to turn to the first talk, and the good thing is that's me, so I can't get too angry with myself. Although I am going to put my timer on to make sure I shut up at the allotted time. So, since Me Too went viral in 2007, the FCA has repeatedly stressed in speeches and publications its intention to clamp down on non-financial misconduct. To date, however, the FCA has only prohibited 7 individuals for non-financial misconduct. All but one of those cases has related to a criminal conviction or a caution. And that limited number of cases and the almost non-existent explicit regulatory guidance has led to some uncertainty as to the scope of the FCA's authority. And it's also led to inconsistency between firms in their approach to dealing with and reporting allegations of non-financial misconduct. So in today's talk, Joseph and I are going to look at where we are, what's coming, and how to deal with it. So the first question perhaps is, what is non-financial misconduct? Well, there's no legal or formal definition, and the FCA handbook currently provides no guidance as to what it regards as non-financial misconduct and when it considers it to be a regulatory matter. And at the risk of being accused of stating the obvious, non-financial misconduct is any misconduct that is not financial misconduct. Well, that's clear, isn't it? Thank you very much. I shall go home now. But it may include a whole host of matters that occur within the workplace where that conduct affects the individual's ability to perform their regulatory role. And it's a deliberately broad concept which covers bullying and harassment and the sorts of things that we're used to seeing in normal everyday employment practices. And there are 3 key areas of the senior manager certification regime which comes into play when one is considering non-financial misconduct. Firstly, the conduct rules, which are set out in the FCA's Code of Conduct Sourcebook, or COCON, and the PRA's Rulebook. And I've set out on this slide and the next the 2 tiers of conduct rules. The first, which are the individual conduct rules, which apply to pretty much everybody apart from ancillary staff, and then the senior management conduct rule, which applies to senior managers. And the current COCON guidance gives examples of conduct that the regulator would consider to be a breach of Conduct Rule 1, which is the obligation to act with integrity. The problem, for present purposes, however, is that the examples all relate to financial misconduct. Now, it's true that the examples are said to be non-exhaustive and therefore don't preclude the possibility of non-financial misconduct constituting a lack of integrity. But there isn't any guidance as present as to when that may be the case. And there is much the same issue at the moment in relation to fitness and propriety. The fit and proper test for employees and senior personnel, or the FIT module of the FCA handbook, identifies when fitness and propriety is to be assessed and provides guidance setting out the criteria to be considered. And the test focuses on honesty, integrity and reputation, competence and capability, and financial soundness. But again, the non-exhaustive list of factors identified in FIT for assessing integrity are all focused on financial misconduct. I've set out on the slide a summary of the current rules in relation to regulatory references, just by way of reminder, and we're going to look at the proposed changes in a moment. But just for present purposes, remember, of course, that the regulatory reference must disclose any disciplinary action taken for a breach of the conduct rules or a finding that an individual is not fit and proper, or that it includes information relating to a person's fitness and propriety. So where are we going? Well, in September 2023, the FCA and the PRA published consultation papers looking at non-financial misconduct and making proposals for change. And the purpose of those proposals is firstly to amend the FCA handbook to reflect the FCA's publicly expressed view that non-financial misconduct is misconduct, pure and simple. It's not an additional principle. To establish minimum principles, and also to give firms a better understanding of regulatory expectations and the reassurance needed to take decisive and appropriate action against employees for examples of non-financial misconduct. Now, although the new rules and guidance aren't likely to come into effect until early to mid-2025, firms should be thinking now about the changes and adapting their processes and approach. In relation to the conduct rules, there's going to be a new COCON Rule 1.3, making clear how COCON applies to non-financial misconduct and when such conduct will breach the conduct rules. And it's going to be made clear that serious misconduct is covered, and that will include instances of bullying, harassment and similar behaviour. And guidance is going to be included which will help firms understand what is meant by serious misconduct and to make clear that it's not every instance of misconduct towards a fellow member of the workforce that will amount to a breach of a conduct rule and require reporting. And it's also intended that the guidance will provide a non-exhaustive list of examples of conduct that will amount to a breach of Rule 1, the obligation to act with integrity, but also Conduct Rule 2, which is the obligation to act with due skill, care and diligence. And the proposals state in terms that conduct that relates entirely to a person's private or personal life are outside the scope of COCON. Now, the guidance, as I said, will or currently includes, in a draft form, the list of relevant factors to take into account when when deciding whether misconduct in relation to a fellow member of the workforce is serious enough to amount to a breach of Conduct Rule 1. And those are set out on the slide. And apologies for the fact, if you look at the print, you're going to have to get your magnifying glass out and squint a bit. There are also going to be a non-exhaustive list of examples of the type of conduct that will breach Conduct Rule 1. And note that bullying, sexual harassment, victimization, and subjecting a colleague to a detriment for blowing a whistle are expressly stated to be a breach of Conduct Rule 1. There seems to be, in the proposals, a sort of get-out-of-jail-free card, which suggests that non-financial misconduct will fall outside the scope of Conduct Rule 1, so there won't be a breach of the obligation to act with integrity, if the certified person thought that there was a good and proper reason for their conduct, they didn't intend it to have a negative impact on the subject of the misconduct, they didn't know that they were having a negative impact, and they weren't reckless about the effect of their conduct. An unreasonable belief, however, that conduct is justified may itself be a breach of Conduct Rule 1 and demonstrate a lack of integrity. And the proposals state in terms that bullying, sexual harassment or violence can never be justified. The reality, however, is that this get-out-of-jail-free card can only be played once, because after that it's going to be nigh on impossible to establish that the individual genuinely believed that they had a good and proper reason for their conduct, or they didn't realise the impact that it would have on somebody else. Now, even if conduct doesn't fall within the scope of Conduct Rule 1, it may still amount to a breach of Conduct Rule 2, which is the obligation to act with due skill, care and diligence. And the draft guidance gives a non-exhaustive list of examples of that sort of conduct, which broadly speaking includes failing to take reasonable steps to protect staff about the type of conduct that will breach Conduct Rule 1, and also failing to take seriously or to deal effectively with complaints of behaviour that will amount to a breach of conduct rule 1. So in essence, that's more targeted at management and how they have dealt with negative behaviour that could breach conduct rule 1. So once we get section 40A of the Employment Act coming into force, which I know Graham and Nick are going to talk to you about later, a bank losing a discrimination claim may not just find itself facing having to pay uplifted compensation, it's also going to need to consider investigating those who are responsible for the conduct that was in breach of Conduct Rule 1, who failed to take reasonable steps to protect their staff, and they'll have to consider investigating and disciplining. There are also proposed changes to the guidance in relation to the fit test, and examples of non-financial misconduct which impact the fit and proper test are likely, according to the consultation paper, to include sexually or racially motivated offences and conduct that could damage public confidence. And that sort of conduct is likely to mean that a person is not fit and proper. And the important thing to note in relation to the fit test is that the proposed new guidance expressly states that misconduct in a person's private life may be relevant to their fitness and propriety to work in financial services. And the draft guidance identifies the sorts of matters that are going to be relevant to consider. And note that one of those is whether a person has been found guilty of discrimination in internal processes or by a tribunal. I think the difficulty for firms is going to be in understanding the extent to which they're going to be required actively to explore individuals' conduct outside of the workplace in respect of their fit and proper assessment. And if we assume that firms are not going to be expected to proactively investigate employees' private lives unless they're on notice of an issue, that really is begging the question then, what amounts to being on notice? And I think firms are going to have to give that some considerable thought. The current regulatory reference regime provides that firms must disclose any disciplinary action taken for breach of a conduct rule or any finding that a person is not fit and proper, and any information relevant to an individual's fitness and propriety. Again, that's not changing, save that the new proposals make clear that non-financial misconduct, whether in the workplace or in one's private life, must be included in a reference if it breached a conduct rule or it could impact on fitness and propriety. And just finally, it is proposed to amend the threshold conditions sourcebook to expand the list of non-exhaustive examples of matters that the regulators may have regard to when assessing a firm's suitability. And that expanded list is going to include where a firm or a person connected with a firm has been convicted of a sexual offence or racially motivated or violent offence, and also whether a firm or person connected to it has been found by a tribunal or court to have engaged in discriminatory practices. So firms are really going to have to ensure that they have solid systems and controls in place to prevent non-financial misconduct. And if there is a tribunal finding against individuals within the firm, then the firm is really going to have to look at the action that it takes against those individuals, but also in relation to its own systems and processes, because it may find itself in regulatory problems. I'm now going to hand over to Joseph to look at some recent cases, and I shall pop back in a moment.
Thank you, Carol. I'm going to spend a few minutes considering what the case law reveals of the regulator's view of non-financial misconduct. As Carol's already said, the FCA has repeatedly stressed that it takes non-financial misconduct seriously and regards it as being within its scope, but it's all remained rather blurry, and there's a limited amount of guidance, and even less case law, it has to be said, including on the difficult question of when conduct impacts on integrity such that it justifies a regulatory sanction. Now, the case I've cited here on the slide is the first time that the upper tribunal has been required to consider a case where a prohibition order has been made by the FCA on the basis of a conviction for a criminal offence not involving dishonesty and where the behaviour was unrelated to the individual's regulated status. Briefly, the facts of Frensham: he was a financial advisor, sole director of a financial advisory firm. He was convicted of a child grooming offence, given a suspended sentence, and placed on the sex offenders register. The FCA determined subsequently that he was not a fit and proper person and withdrew approval. He then referred the matter to the upper tribunal, arguing that there shouldn't have been a finding of a lack of fitness and propriety for three main reasons. First, that his conviction didn't involve findings of dishonesty. Second, that it related to events that took place entirely outside of the workplace. And thirdly, that there was no sufficient link in his submission between the criminal conviction and his role as a financial advisor. Now, the outcome was that the upper tribunal dismissed the reference. The first important point that the tribunal made in its reasoning was that a conviction for a criminal offence will not automatically mean that an individual lacks fitness and propriety within the meaning of the regulatory code. It's a question of taking into account all of the relevant factors, and those relevant factors are set out there on the slide. Turning to the important question of integrity, the upper tribunal engaged in a quite helpful review of various Court of Appeal and High Court authorities, drawing on the principles as they've been analysed in cases concerning solicitors' professional obligations. And following that examination of the authorities, the conclusion of the upper tribunal was that there had to be a clear connection between the conduct committed and the rules and standards of the profession. It was not enough either that the conduct would merely breach acceptable standards or that it might provoke a public outcry. So there's a somewhat higher test. And the tribunal went on to set out various circumstances where it might be said that an individual's personal private activities might impact on their integrity in their professional life. Come on to those in a moment. But first and foremost, what is integrity? Well, the upper tribunal said it simply means adherence to the ethical standards of the profession concerns. And in matters touching on an individual's professional standing, there is, quote, an expectation that professionals may be held to a higher standard than those that would apply to those outside the profession. Having said that, fortunately for all of us, a regulatory obligation to act with integrity does not require professional people to be paragons of virtue, in the words of the upper tribunal. But the need for public trust in the provision of professional services means that some scrutiny of a person's private activities is permissible. But whether or not integrity comes into play depends on whether the conduct in the person's private life realistically touches on their fitness to practice within the profession and whether it engages the standards of the relevant professional code. And in considering that question, the decision maker, in this case the FCA, has to take into account whether public confidence would be adversely impacted if the public, knowing all the facts, discovered that the person under scrutiny had continued to practice in the profession. So, as I said a moment ago, it was not enough merely that the conduct would breach acceptable standards of behaviour or provoke an outcry. There has to be a link between the conduct and the manner in which the professional proposes to serve the public. Now, by way of an interesting aside, the upper tribunal found that the FCA had failed to articulate properly how Frensham conviction would undermine consumer confidence or the integrity of the financial system. Somewhat strikingly, he, Frensham, had in fact retained quite a number of his clients post-conviction, and the FCA's case had been put simply by reference to an assertion that approved persons should demonstrate the utmost integrity and reputation. That aspect of the FCA's case was found to be speculative and unconvincing. Somewhat damningly, the upper tribunal went on to say that the FCA's case would have benefited from, quote, a more independent analytical justification of the link between the offence and public confidence. And what the upper tribunal suggested in practice was that either psychological or criminological expert evidence would have been helpful to demonstrate whether or not the offence committed by Frensham would have demonstrated a propensity on his part then to exploit other vulnerable clients in the future, such as elderly clients who might rely on him. Now, despite all those criticisms, the FCA's decision was upheld, mainly for the reasons given here on the slide, which I'll run through briefly. The offence occurred while Frensham was subject to bail conditions. He was aware of those conditions, but disregarded them. That was found to show that he had a disposition to disregarding the law and to pursuing his own interest. Moreover, he had attempted to rationalise his behaviour, shown little remorse. He'd also delayed informing the FCA about matters relevant to his conduct in order that he could arrange his business affairs and present the most favourable position. And finally, there was a lack of transparency overall in his dealings with the FCA, a point which I'll come back to in relation to a case in a moment. So it's notable that it was not, in fact, the nature of the offence itself that affected his regulatory status, but rather it was his failure to observe his bail conditions and failure to provide timely and complete information to his regulator. There have been some other cases in which the FCA has announced prohibition notices for non-financial misconduct. The three named here on the slide were prohibition notices handed down in November 2020. They're unrelated cases, but they all concerned non-financial misconduct in the form of a conviction for a sexual offence. And the reason given for the prohibition was either an abuse of authority or breach of trust. There's not a huge amount that we can glean from the FCA, from the notices of the FCA's reasoning, but what the FCA does focus on is the sentencing remarks of the individual judges, and I've given a flavour of them there on the slide. And that demonstrates really the kind of factors that the FCA is going to consider as material to the integrity question. And in the light of the issuing of these three orders in quite close proximity, the then FCA Director of Enforcement and Market Oversight reiterated that the FCA takes seriously questions of character, probity and fitness, and will take action to ensure that they are maintained. Now, lastly, with an eye on the clock, I will just take a brief look at the enforcement action taken against Atrium by Lloyd's of London. This was the first case of UK enforcement action taken by the regulators involving non-financial misconduct that took place in the workplace or at work-sponsored events. Also, the first enforcement action to examine the adequacy of a firm's response to allegations of such misconduct. I note that this was action taken by Lloyd's as opposed to the FCA, but given that the FCA regulates both Lloyd's and its members, it's fair to assume that the FCA was kept updated as the investigation went along. And you can see there the severe sanctions that were meted out at the end, along with a not insubstantial costs order. Now, Lloyd's had identified several instances of non-financial misconduct that had taken place at Atrium over several years. And in high-level conclusion, Lloyd's found that this had precipitated a culture which tolerated instances of unacceptable conduct involving discrimination, harassment, and bullying. So the full suite of non-financial misconduct. Most of the misconduct related to the misconduct of one particular employee, employee A, who'd engaged in a campaign of bullying and discrimination against a junior employee. But perhaps more significantly, this conduct was generally known to the senior management of Atrium, with no adequate steps then taken to deal with it. I'll just briefly run through some of the really key findings that the regulator made in respect of Atrium's response. So Atrium, first and foremost, failed to challenge or even acknowledge the conduct. And that failure was motivated, and this will be a recurring theme as we run through this, it was motivated by a desire on the part of the firm to avoid bad publicity, which is plainly an illegitimate motive. Atrium also failed to properly identify and investigate the complaints in accordance with its own internal policies. That resulted in a failure to protect the complainant. Atrium also failed to take disciplinary action against employee A, instead offering him a settlement agreement which allowed him the opportunity to resign rather than face sanction. That again was motivated by the desire to avoid adverse publicity. Compounding matters, Atrium then instructed the complainant not to speak about or discuss the investigation or the allegations made. And then, perhaps quite extraordinarily, at the conclusion of the internal investigation, employee A then raised his own counter-complaints against the original complainant, which Atrium then investigated without any consideration whatsoever as to whether that might amount to retaliation or victimization. And again, as we saw in respect to one of the earlier cases, there was a failure to act with transparency towards the regulators. So it's only one case, but it does give a steer as to the factors that will be regarded as important by the regulators. They include abuses of power, patterns of bullying and discrimination, failures to protect complainants, senior management minimizing, even condoning serious misconduct and failing to take it seriously, and the lack of transparency and openness with the regulator. I'll hand back over to Carol.
Thank you, Joseph. And I think the clear message that can be taken from all of what we've just looked at is that it is essential that firms implement and operate robust processes to identify and handle allegations of non-financial misconduct when they arise. And there must be nothing within the processes which looks as if firms are condoning or tolerating bad behaviour. And firms are really going to have to look at their corporate governance and culture. And one of the criticisms in the Atrium case was the fact that there had been an annual sort of boys' club evening, which senior managers had attended, during which male employees, including those in leadership, had engaged in unprofessional and inappropriate conduct. That simply can't be tolerated. Also look at whether or not there is a culture of people feeling able to speak up about cultural issues. Is the appraisal process robust enough to pick up on issues of non-financial misconduct, either because the process itself lacks robustness or those who are charged with conducting appraisals aren't adequately skilled and trained to do so? Another thing to think about is, are there processes in place to ensure that there is no retaliation from people who raise concerns of non-financial misconduct? And I'm not just talking about obvious retaliation, but processes that perhaps need to be monitored over a longer period of time, such as appraisal processes, promotion processes, remuneration processes, to see whether there are adverse impacts over time against people who've raised concerns. And of course, when allegations of non-financial misconduct are made, it is essential that HR works together with legal and compliance in order to consider whether there are potential conduct rule breaches, any reportable potential conduct rule breaches, and any need to assess fitness and propriety. But remember, however, that allegations of non-financial misconduct can be nuanced, and it's not going to be every breach of an internal policy or non-financial misconduct which will amount, as far as the regulator is concerned, to a breach of a conduct rule. It's serious cases. So firms are going to really have to give some thought as to what is meant by serious and be able to articulate it in every case, because of course the individual who finds themselves dismissed because a firm simply takes the approach of saying any non-financial misconduct is serious is itself creating a risk that could find itself in problems with the regulator. And of course, if there are allegations of non-financial misconduct made, it's essential that they are investigated fully and fairly and in an even-handed way, particularly given the potential career-ending consequences. Avoid, as Joseph said from the Atrium case, allowing people to resign with settlements when there are allegations of non-financial misconduct. And finally, don't forget that more than one person can be impacted by a finding of serious non-financial misconduct that amounts to a conduct rule breach. Look at and consider whether there are people higher up the chain who might also have their conduct and their abilities called into question for failing to spot it and failing to manage it. And that is us on non-financial misconduct. And now I'm going to hand over to Dan Northall and Sophie Castle.